the Commission on Human Rights and Restorative Justice has recommended a forensic audit and potential prosecution of the trustees of the National Cathedral project. This comes after an investigation into allegations of corruption and abuse of power regarding the controversial project. Now, the findings were contained in a report dated November 22, 2024, following complaints by Northton MP Samuel Okudzeto Ablakwa. The report highlighted several breaches of Ghana's procurement laws, particularly in the award of the construction contract to Rebate Company Limited. CHRAJ concluded that the contract was void ab initio for being entered into contrary to the mandatory provisions of the Procurement Act 663 as amended by Act 914. The report, signed by Joseph Whittle, who is a commissioner of CHRAJ, called on the Public Procurement Authority to intervene and cancel the contract with Rebate Company. The board of the Public Procurement Authority should intervene to cancel the contract for the construction of the National Cathedral between National Cathedral and Rebad, as it has the power to do so under the Procurement Act, it quoted. Additionally, CHRAJ urged the Auditor General to conduct a forensic audit of the project, citing concerns about the 229 million cedi spent as of May 31, 2022, described as seed money. This sum of money has been expended on site preparations, contractors mobilization, U.S. fundraising, consultants, and symposia, the report noted. Public interest dictates that there ought to be value for money in project execution. Unfortunately, this commission has no expertise to determine whether there has been value for money, considering the project remains in the same state. CHRAJ expressed concern over the reputational risks posed by the project controversies, emphasizing that breaches of procurement laws could attract international embarrassment to the country, considering its international status and that of Rebate Company. The Commission further recommended the Board of Trustees of the National Cathedral be subjected to investigations and possible prosecution for their role in awarding the contract in violation of procurement laws. The Commission further recommends for further investigation. Okay, the investigation was triggered by, of course, Okudzeto Ablakwa's petition. The government and the board have not yet responded to this. There were a couple of issues, whether Reverend Kusi Boateng owns two different passports with two different names. It was confirmed that his passports bore the one name, Kwabena Edu Jemfi. And then on the issue of conflict of interest, the report did not find evidence to prove same. All right. Then there's also the So let's listen to first Bobby Banson. He's a lawyer for Reverend Kusi Boateng, whose passport bears the name. What's the name? Forgive me. Whose passport bears a different name, but of course the claim was that he had two different passports, two different names. His passport bears the name Kwabena Edu Jemfi, and according to the report, he holds only one passport with the name. All right. Now, Mr. Okudzeto Ablakwa had petitioned and on a number of things: the different passport names, conflict of interest in award of a contract to a company called JNS Talent Center, which is owned by the same Reverend Kusi Boateng, under the secondary identity Kwabena Edu Jemfi. CHRAJ concluded that no service was rendered by JNS Talent Center, owned by the Reverend Kusi Boateng, under his secondary identity Kwabena Edu Jemfi, and that there was no evidence of the said payment, thus clearing him of conflict of interest. Now, I will get you to read full. There are other highlights of the report that are available, but I want to just take Bobby Banson's reaction to the issues around the two different names, two passport, conflict of interest. Then we'll hear the petitioner's own response before we get into other details of the report if there's time. So here's Bobby Banson speaking to Umaru Sanda Amadu.
I believe that we can all accept that we cannot have different facts in respect of the matter. The facts that were alleged by the complainant did not support his allegations with the evidence when it mattered most. CHRAJ has investigated, come to those conclusions. The two most important conclusions: that he had two different passports with two different names. It found out that has never been the case. The second conclusion is that he received money for work that he claimed he had done, and the CHRAJ found out that the money was never paid because of work. It was a refund or reimbursement of an amount that was advanced without one single cent of interest on it. So there was no conflict of interest situation that arose. At all points in time, the handlers of the National Cathedral knew that this same person was Kwabena Edu Jemfi or was Victor Kusi Boateng. The only other issue is whether or not he has two tax identification numbers and he obtained them in a manner that was illegal. CHRAJ said they do not have the capacity to investigate that. That is already before the the Ghana Revenue Authority. They are investigating that. Perhaps they will come out with their final findings at a later date. But as it stands now, all the allegations that have been made, none of them has been proven so far.
Was your client heard, though, in the investigation?
Oh, yes. CHRAJ asked for written responses, which we did. Remember, it was Reverend Victor Kusib-Watson, JNS Talent, and the other directors. There were oral hearings with the other directors, not Reverend Kusib-Watson directly. But all the responses that were required by us, we provided it with all the supporting documents. So I would confirm that indeed CHRAJ gave us an opportunity to be heard.
What's the consequence of this decision? Does it then mean that your client is only now known as Reverend Kusib-Watson and not Kwabena Edu-Gyamfi, as was claimed by the Member of Parliament? Or this will simply be an alliance that he uses, which does not necessarily impugn any wrongdoing?
Well, we have always maintained that the proof of identity in our country is either your Ghana card or, in the worst case scenario, your passport. And there is no evidence that he's ever obtained a Ghana card in another name apart from Kwabena Edu-Gyamfi. There is no evidence that he's obtained a passport in another name other than Kwabena Edu-Gyamfi. And so that settles it. And CHRAJ said there was no other evidence before them that he had obtained a passport or any other legal document, be it the Ghana card, in any other name apart from Kwabena Edu-Gyamfi.
How is your client proceeding after this clearance of his name? Are there any actions you're going to take subsequent to the decision by CHRAJ?
Well, he had always knew this would be the conclusion because he knew the truth, and the truth is only one. The truth always stands. You recall that we commenced the defamation suit, which is still pending, based on the allegations that had been made by the complainant, and so I'll not be able to speak into those matters as well as it's still sub judice.
Very well. And in proceeding, the other aspects where CHRAJ said it did not have capacity, would that be an area that you're going to explore further, or because no decision has been taken, you leave it as is?
No, we have not filed a complaint with any other person. The person who has filed the complaint has the burden to prove and to follow it through. As far as we are concerned, everywhere we've been asked to respond to those allegations, we have provided the necessary documents. And so that ends it for us.
Now, while you are celebrating the CHRAJ victory, there was an earlier decision of the High Court on this same matter. When you weigh the two, which one should we deal with? The High Court decision on the one which Ablakwa seems to be holding as a flag of victory, suggesting that he has ended up being victorious. You also holding on to the decision of CHRAJ. Which one should we deal with?
Well, we are not holding on to any decision as the basis of our client's innocence. The truth and the facts and the evidence in support are there. Like I said, we cannot have different opinions, but there can only be one set of facts. And the set of facts is what has been found and concluded. We didn't go to CHRAJ. And so we are not saying that we needed CHRAJ's decision to be able to clear, or as it were, confirm that our client has not done anything illegal as had been touted by the complainant. In any event, that decision of the High Court is the subject of an appeal. And so we would also not speak into that because it's subject of an appeal pending currently at the Court of Appeal.
All right, so those were just highlights of that interview. So as I say, there were issues around a potential dual identity, and what CHRAJ did was to look at the documents available to them, which is the passports and the diplomatic passport, and say it's the same name. All right. Then there's the issue of conflict of interest, which they say they did not find. Then there's the issue of procurement breaches, which they say are rife, which they believe merit the stoppage. First, they said that the Public Procurement Authority can stop specific procurement, and then they think that there's further investigation required either by the Aegis Department or the Special Prosecutor. All right. So there's a lot of things in the report. It's 165 pages, by the way. Let's hear Okujeto Blackwell's reaction to this before we can get into some other highlights of the report.
They don't keep records. National Cathedral Secretariat also didn't keep records. The CHRAJ report actually recommends that they should take all of them through a course on proper corporate governance. Your summary of the CHRAJ report is not what I get when I read the CHRAJ report. And you may have to read the report again. CHRAJ only says on the matter of passports that when they went into the database of passports, they found out that all passports were in a particular name, Kwabena Edu Jemfi. That's all what CHRAJ is saying. And that confirms the point I have always made, that he was appointed as Victor Kusi Boateng to the board of the National Cathedral Board of Trustees. However, when the state decided to give him a diplomatic passport to carry out his work, that diplomatic passport was issued in a different name, not in Victor Kusi Boateng, but in Kwabena Edu Jemfi. The CHRAJ report is confirming that his diplomatic passport, indeed all his passports, are in the name Kwabena Edu Jemfi, not Victor Kusi Boateng. The CHRAJ report has not disputed the double identity scam he engaged in. Indeed, when you read the report fully, CHRAJ says that they are recommending the double identity scam he engaged in to the Attorney General for further investigation. Because I produced evidence from the DVLA, where over there in the DVLA database, he operates as Victor Kusi Boateng. I also produced evidence from the GRA, the Ghana Revenue Authority, where he is operating in a dual capacity. He has a set of companies he incorporated under the name Victor Kusi Boateng with a different mother, a different date of birth, 2 years apart. And then a different set of companies he operates as Kwabena Edu Jemfi. CHRAJ is saying that all of those matters, the Attorney General should investigate them. But it is only on the issue of passports that they found out that he doesn't have two different passports. All the passports are in the name Kwabena Edu Jemfi. So I am shocked to be seeing headlines that he has been exonerated. Exonerated on what? The fact that he has engaged in a double identity scam has not been cleared. Read the CHRAJ report carefully. He has not been cleared of that. And don't forget that a high court, the Human Rights Court, had the opportunity to go into this matter. And he dragged me to that court saying that I had violated his right to privacy, had violated his fundamental human rights, and that what I had put out was not true. When the court looked at the evidence, the court, in his judgment, said everything I had put out is true. That what he did, to quote the court verbatim, that his conduct borders on criminality. That's not me saying. That's the court. So let's be careful. There's a lot of propaganda out there. I know that election season, this is somebody who we all know is a top advisor to Bawumia and Akufo-Addo. The MPP is desperate to have seen a lot of MPP propagandists distort the CHRAJ report and say that he has been cleared of double identity. They should quote a paragraph where CHRAJ states that this man has not engaged in a double identity scam. I challenge them to produce any portion of the report. All CHRAJ has said is that they didn't find two passports in two different names. But doesn't it hit you as strange that somebody is appointed as Victor Kusi Boateng, official capacity, official position, and then when it comes to a diplomatic passport being issued for the person to carry out his official assignment, it is issued in a different name, Kwabena Edu Jemfi. So this is, look, until my expose, who in this country knew that Victor Kusi Boateng was Kwabena Edu Jemfi? Who? So this is actually a confirmation of everything I've put out. So I don't see how this will amount to an exoneration or me having been defeated as CHRAJ. It's all just empty propaganda.
Okay, I want to lift a few of the claims that have been made by the Commission in its report. I'm looking at page 141, and if you will indulge me, I just want to read that.
Sure.
It says that searches through to 2021 indicated that, quote, there is no Victor Kusi Boateng in the passport database, unquote. The data provided the Commission shows that the fourth respondent currently holds one non-extant passport number, has been quoted here, issued on 27th October 2021 and set to expire on 26 October 2031, and one diplomatic passport with the number quoted here on 25th November 2021, expiring on 24th November 2025. Two ordinary passports earlier issued to him have since expired. Based on the evidence before it, the Commission finds that, contrary to the complainant's allegations that the fourth respondent, Victor Kusi Boateng, aka Kwabena Edu-Gyamfi, holds two different passports, each bearing one of his two names with different dates of birth on each document, the fourth respondent rather holds one diplomatic and one ordinary passport only under his name, Kwabena Edu-Gyamfi. For avoidance of doubt, at no point in time has the fourth respondent been issued a passport under his name, Victor Kusi Boateng. So this is in response to the issue 7 in your petition. Now, if you look at that carefully, the Commission is saying that in your petition, you allege that he had two different passports with two different names and two different dates of birth. The Commission is saying it has not found any such thing.
Yes, that is on passports. And the foreign minister said so in Parliament when I filed a question on this matter. The foreign minister, if you recall, and listeners can Google this, the foreign minister said that the passports issued to Victor Kusi Boateng were issued to him in the name Kwabena Edu-Gyamfi. CHRAJ should have proceeded to analyze all the other IDs. Why did CHRAJ, in this particular paragraph, in this page, why did they focus on only the passport database? Why didn't they go into the DVLA database, where he operates as Victor Kusi Boateng? Why didn't they go into the GRA database, where he operates as both Victor Kusi Boateng and Kwabena Edu-Gyamfi with different things?
8:39 on the Citi Breakfast Show, which Eto Ablakwa speaking to Umar Sandamon. This coming up shortly. I think there are more grave issues beyond even name and the conflict of interest. There are more grave issues around the procurement, the amount of money spent, and what CHRAJ is now recommending to be done, which I think because of the fuss around the names, that has been glossed over. All right. So if you and by the way, if you look at the members of the board of trustees of National Cathedral, these are very prominent people in society. So if you go to page 137, it says this call for investigation and subsequent prosecution, if necessary, is directed at members of the board of trustees of the National Cathedral who were members as of 2021, and Dr. Polo Puku Mensah, Executive Director of the National Cathedral of Ghana, when the contract for the construction was awarded to Rebate Company Limited. The trustees include Apostle Professor Puku Nyina, Chairman of Pentecost Chairperson, who is the chairperson, Archbishop Charles Palmer Buckle, Metropolitan Chief Archbishop Cape Coast, who is the vice chairman, Most Reverend Bishop Justice Ofeya Krofi, Anglican Archbishop Emeritus, who is a member, Most Right Reverend Professor Emmanuel Mati, former moderator of the Presbyterian Church, member, Most Reverend T.K. Awachi Pratt, presiding bishop of the Methodist Church, member, Archbishop Nicholas Duncan Williams, presiding Archbishop and General Overseer, Action Chapel International, member, Reverend Dr. Joyce Ayi, Executive Secretary, Salt and Light Ministries, member, Bishop Dark Heward Mills, presiding Bishop Lighthouse Group of Churches, member, Reverend Isudanaba, founder and president, Isudanaba Ministries, member, Reverend Victor Kusi Boateng, founder of Power Chapel Worldwide, member, stroke secretary, and Reverend Dr. Frimpong Manso, General Superintendent, Assemblies of God,
Former.
At the time. Yeah. Now, so that's issue 5. All right. And now, if you get into the findings and the recommendations, they now talk about the role they think the Special Prosecutor or the Attorney General can play, And then they also then do the procurement issues, which they believe clearly there were procurement breaches. So it's, for me, I think it's a damning report, right? I think it has more, it agrees more with the petitioner than it disagrees with him, except, of course, on the issue of conflict of interest in the matter of JNS talent. But, of course, people are picking the part that has been in the news, the name and that type of thing, right? But it's a very serious report, which is essentially saying that the way the procurement was done for the project was not right, and that the Public Procurement Authority should deal with it, right? So let me read some of the recommendations for you.
Please do.
Now, in light of the foregoing, 162, and in light of commissions taking note of the fact that the Board of Trustees of National Cathedral are all clergymen who may or may not be well versed in corporate governance, the Commission recommends additionally the capacity building and on good corporate governance be organized for the board members by credible professionals such as the Institute of Directors, Ghana, to sensitize them on good corporate policies and practices in the conduct of their official duties. Also of crucial importance is the amount spent so far on the cathedral. Our investigation showed that as of 3rd May 2022, the amount of 225,962,500 Ghana cedis, described as seed money, had been released for the construction of the National Cathedral per Exhibit 9. This sum of money has been expended according to Exhibit 9 on site preparations, contractors mobilization, US fundraising, consultants and symposia. The stated sum of money is no small amount. Public interest dictates that there ought to be value for money in project execution. Unfortunately, the Commission has no expertise to determine whether there has been value for money, considering the project remains in the same state. Accordingly, the Commission recommends that the Auditor General should conduct a forensic audit on the construction of the National Cathedral project from its inception to date to ascertain whether monies released for its construction have been properly utilized. Having found that the contract awarded to rebate company is void ab initio for being entered into contrary to the mandate provision of the Procurement Act, the Commission also recommends that the Board of Public Procurement Authority should intervene to cancel the contract for the construction of the National Cathedral between the National Cathedral and rebate company, as it has the power to do so under the Procurement Act. The Commission further recommends for further investigation and possible prosecution of the Board of Trustees of the National Cathedral, who superintended over the award of the contracts to rebate company in disregard of Act 663 as amended. These breaches of the procurement laws have the potential of causing international embarrassment to the country, considering its international status and that of the company. I'm going back to the earlier recommendations, So let's do observations and recommendations. The Commission notes with great concern the informal nature surrounding the processes leading up to the transfer of the money to the National Cathedral by the 5th respondent. Administrative lapses at such high positions should not be countenanced. Good corporate governance requires that minutes of directors' meetings ought to be taken and kept in a minute book. Guys, this is National Cathedral. This is to ensure the documentation of key issues discussed at meetings. Unfortunately, both the National Cathedral of Ghana and the 5th respondent company failed to take minutes of meetings under which the issue of financial assistance was discussed. Most importantly, Section 1883 of the Act 992 mandates minutes of meetings of directors to be taken and kept in a book. Section 1883 provides thus: a company shall cause minutes of the proceedings of meetings of the directors and a committee of directors to be entered in a book or books kept for the purpose. On the issue of absence of minutes, the board chair of the 3rd respondent stated thus: documentation on issues involving the National Cathedral of Ghana and JNS Talent Center from January 2020 to September 2021. Kindly note it was a normal administrative transaction and it was therefore not recorded in the minutes of the book. It was an offer made by JNS Limited, which was paid within a short period. The 5th respondent, through his representative, the 6th respondent, also stated during his interview with the Commission that, quote, our modus operandi is that we agree among ourselves and not to take minutes of directors' meetings. This is rather a very unfortunate situation and needs to be discouraged. It has the potential to cast doubts in the minds of ordinary men of the integrity of transactions and it's a very dangerous practice. Guys, this is CHRAJ, I'm quoting, these are not my words. Now, they are commenting on the Citi respondents' response, who said that their modus operandi is that they agree among themselves and do not take minutes of directors' meetings. And according to CHRAJ, this is a rather unfortunate practice that needs to be discouraged, which has the potential to cast doubts in the minds of the ordinary man on the integrity of the transactions, and is a very dangerous practice. Go on. The danger of such informality in handling of affairs is evidenced in the situation where the resolution of the fifth respondent's company to transfer money to the National Cathedral predated the formal request for the company by the third respondent. The resolution to transfer money to the National Cathedral by the third respondent was passed on 25th August 2021, whereas the formal request for the loan by the National Cathedral is dated 26th August 2021. In light of the foregoing, and in light of the Commission taking notice of the fact that the Board of Trustees of the National Cathedral are all clergymen who may or may not be well versed in corporate governance, the Commission recommends additionally that capacity building on good corporate governance be organized for the board by credible professional bodies such as IOD to sensitize them on good corporate governance. And then the 225 million cedis described as seed money, according to the Commission, is not a small amount, and that public interest dictates that there ought to be value for money in project execution. But because the Commission, which is CHRAJ, has no expertise to determine whether there's been value for money or not, they are recommending that the Auditor General should conduct a forensic audit on the construction of the National Cathedral project from its inception to date to ascertain whether monies released for its construction have been properly utilized. Having found that the contract awarded to rebate is void ab initio for being entered into the contract, they recommend that they cancel it. All right. Now let's go to conclusion. In conclusion, the complaint is justified in part at the end of the investigation. The claim of conflict of interest relating to the fourth respondent is without merit based on the result of investigations, while allegations of breaches of mandatory procurement provision under the Public Procurement Act as amended have been justified. Right, which is why Umar Rusana said it is 1-1 draw. On the issue of conflict of interest between Reverend Kwesi Boateng and his company, they did not find. But on the issue of procurement breaches, they did find. The Commission takes the opportunity to express its gratitude to the parties, especially the complainant and his lawyers, for the cooperation extended to the Commission during the investigation. Signed by Dr. Joseph Whittle, 22nd November. So this came on Friday. Somehow it got into the media yesterday. Let me summarize the relief sought, if you have them in front of you, because I think it will be important, because they dealt with the two key issues, conflict of interest and procurement breaches. But the petitioner had at least 5 reliefs he was seeking. And I just wanted to share that with the listeners before, if we have any further comments to pass, we will go through. So the petition was for an investigation into state funds paid to JNS Talent Center by the Controller and Accountant General's Department at the National Cathedral of Ghana, pursuant to Article 218 of the 92 Constitution. Now, Nathan, if you can share with me the 5 reliefs.
Yes. So it says it is the petitioner's prayer and the petitioners, of course, Honorable
Okujetua Blakwa.
Yes.
And by the way, first respondent, President, appointee in charge of Ministry of Finance, that's Finance Ministry. Second respondent, head of Controller and Accountant General's Department, a subsidiary agency at the Ministry of Finance. Third respondent is board appointed by the President with oversight over the cathedral. Fourth respondent is founder of Power Chapel, Kwesi Boateng.
Okay.
Fifth respondent is a company limited by shares registered by the Republic of Ghana, that's JNS Talent. Sixth respondent is a branch pastor of the church. Sixth and seventh respondents are together with a certain Kwabena Edujemfi as directors of the fifth respondent, the GNS Talent. So those are the respondents.
Yes. So the relief sought, it is the petitioner's prayer that the Commission, investigates the appointment of contractors for the National Cathedral project, which petitioner believes were done without adherence to the public procurement procedures and laws. 2, investigate payment of a sum of 2,600,000 Ghana cedis and any other payment made to JNS Talent Center Limited from state resources. 3, investigate the conflict of interest complaint against Reverend Victor Kusi Boating, who's the fourth respondent, in his dual capacity under separate identities as director of both the National Cathedral and JNS Talent Center Limited and related matters. 4. To take the appropriate action or steps for the remedying, restraining, correction, or reversal of offending conduct or actions. And 5. To recommend sanctions for offending conduct or action. Signed, Samuel Okudzeto Ablakwa, MP, the petitioner.
I need to point out that some of the board members resigned before this matter got to this stage. So if you remember, Daggy Mills wrote a letter resigning from the board.
Was it before the transactions complained of were made?
I'll check the date.
So
but I recall that he had written a letter to the board chairman complaining about how things were happening, and there was a response in the media from the chairman of the board at the time. So he raised some matters, and indeed, when Okudzeto Ablakwa was filing his petition, he cited, at least in interviews, the challenges that people like Daggy Mills had expressed about the way things were done on the board before his resignation. Subsequently, Duncan Williams and Isu Anaba also resigned from the board. So I'm just putting that out there for the record. Right?
Yeah.
No, I understand where you're coming from. I'm just trying to say that there were. What I do know is that the DAG one, when Ablakwa was filing this, he had already raised those procurement issues. Not procurement, he had raised concern about the way the board was working and written a letter asking for a response. And then the chairman responded to him, and then he subsequently resigned prior to the petition.
Yeah, because the reason I'm raising it is the recommendation for prosecution should be done would affect specific people who at the material time of the giving of the contract impugned were in office as trustees.
I can easily check this. Maul, if you can just retrieve for me the letter and the resignation of Bishop Dag, and also the letter and resignation of Isu Anaba. We'll look at the timelines for that, and then we'll just track that with the specific time. And by the way, though, the amounts of money paid were at different points. And then the procurement of Rebad Company, that one, there's a specific date to it. But the 260 million, there were different payments under by about 6 different items. So we'll need to be a bit more careful to know the specific dates. But I take that point. But it's also important to point out that 3 of the people mentioned to be on the board have resigned.
That's
all right, which is fair. And they gave reasons publicly for their resignation. They had issues with how things were happening. Sky, my concern is a few things. So the meat of the petition, in my view, was conflict of interest by the secretary of the board and awarding a contract to JNS Talent, and then procurement breaches in awarding a contract to the company that did the first part of the project. Somehow, a lot of the reportage has been about a certain clearing of a name, of double identity. I blame the way maybe we media we like that type of story. I don't know, but it seems to me as if you are to weigh the key issues in the relief sought, conflict of interest and procurement breaches are obviously higher than the 2 names, right? Because we're talking about 260 million cedis. If there are procurement breaches in awarding contract of that amount, somebody can have 2 names. I'm not saying it's not a big issue, but almost all the headlines, at least from yesterday, were focused on the name part, which I find a bit troubling.
Okay, let me caveat my presentation knowing that there are a number of matters in the courts surrounding this particular matter, and therefore I'll be careful how I deal with my submissions on the matter, especially given that I am an officer of the court. I have some responsibilities to the court. But this submission is largely for purposes of public education. Now, the mandate of CHRAJ includes, amongst other things, investigating matters having to do with conflict of interest, abuse of human rights, and related issues. It does not include investigating criminal conduct.
Okay.
So when matters of criminal conduct are raised, that is not the proper forum. And even where during the course of the investigations they come to a finding that points to possible criminal conduct, the constitutional provision and the statute, the law governing what they do, allow for references to be made to the appropriate institution, including the Attorney General in this case, for them to do what is needed. So once allegations of possible criminality have been raised in relation to breaches of the Procurement Act. That is why they are referring that aspect of the matter to the Aegis Department for the appropriate investigations and what should happen. Now, coming back to the specific allegation regarding possible double identity, I think I've not read the report fully.
Its entirety.
Yeah, that's right. So let me also issue that caveat. But it does seem to me that CHRAJ's findings are based, strictly speaking, which is allowed to some extent, on the allegation by the Honorable Kujetua Blakwa that the gentleman, he believes, has a passport in a name that is different from what was originally presented. In which case, we are saying that, okay, he has a name, Kusi Boateng, which is a different name, and he has another name, Edu Jemfi, which is another name. And that in both cases, he alleged that he has a name, Kusi Boateng, on the passport, and he has reasons to believe that the name, this is even confusing, Kwabena Edu Jemfi is also on a different passport. Do you understand? Now, it seems to me, reading the relevant sections of the CHRAJ report, CHRAJ is saying that we went into the system, and based on your claim that the man has two different passports, all bearing different names, Edu Jemfi, and then Kusi Boateng, we did not establish that indeed those facts can be upheld by us on the basis of the evidence before us. Are you following what I'm saying?
Again.
And then on the basis of that, they then proceed to hold that they did not find conflict of interest. I hope you understand my logic. Someone alleges that the man has two identities, and the person produces document to show that yes, from the records you can see a certain document suggesting that this is his identity, but the person asserts that he has some other evidence. He believes that the person holds a passport with a different name. The person investigating, in this case CHRAJ, goes into the records and establishes that no, the only document that we have seen is that he has a name, Edu Jemfi, on his on only one passport, and that passport has only that name. As for Kusi Boateng, we have not found that. And then CHRAJ, on the basis of that, it seems to me, proceeds to hold that it did not make a finding of conflict of interest, and that is problematic for me. The reason is that if we say Godfred Odu has another name, which is what? The Lakofi. Right,
the richest man.
The richest man. Let's go with that. We do all know that is his other name. Then he registers a company in the name the richest man. Right. He was appointed to serve on a certain board
as the richest man.
Then he has a passport showing the name Godfred Odu. And then the allegation is made that the person who sits on the board is the same person in person, not in name. You understand? The same person in person, sitting on a certain board, making decisions which appear to create the impression that these are two different people, but in fact, these are the same people. They are one and the same. For which reason there is
potential
conflict of interest. Now, for you to establish that, you don't simply go, and I have so much respect for Dr. Whittle, and I'm not suggesting that he's done I think he's done a fantastic job.
I'll explain to you why they said there was no conflict of interest, but you go on. Go on.
Now, if you proceed on that, and then you come to the conclusion that, you told us that he has two different passports. We found that he has only one passport. And they proceed, amongst other things, to hold that there was no conflict of interest, unless there's some other fact that leads them to that conclusion, and I've not seen that based on what I have read that far, then there is a problem there. Unless you can point me to some area. I've conceded, I've not read a full report. But it will be curious for a finding of fact to be made to that extent without actually uncovering who is actually the Kusi Boateng. If the admission is made that, Kusi Boateng is the same as this Edu Jemfi, and it is the case that within the records of the GRA, we have this other person presenting as this other person. Those are facts that could have been brought up without impugning criminality in there. Because criminality then will fall within the remit of some other person. But to determine whether there was a conflict of interest, we need to know who is Kusi Boateng. And we need to also know who is Edu Jemfi. It seems to me that there is some confusion.
What I'm trying to say is that my understanding of what I've seen, I'm looking for the specific page, is that the conflict of interest is not necessarily predicated on whether it's the same person or not, or whether the transaction did take place, which is where I am going to.
Okay, go to that page. Yes. Because, you see, I heard the explanation that the company gave out some money, and that money was paid back.
I think that's what they're trying to say.
But you see, that would be to look at it on the surface. You need to dig in. Who are the registered officials of the company? And that information, you get it at the Registrar General's Department. What is the identity? What proof of identity did they present at that ministry, at that office, in order to have their company registered? Now, if we can establish that the person who was registered as Kusi Boateng is the same as the person who now presents himself in a different capacity, in this case with some other institution, and that person is taking a decision, which decision affects a state institution in one way or the other, but the person is presenting himself as two different individuals, then there is constructive evidence of conflict of interest. Because it is me, Richard Sky, claiming my ID is this, and claiming in another capacity that my name is this, and yet acting as the same person with two different names, and the circumstances that raise issues of possible wrongdoing. You understand? So the CHRAJ would need to dig deep into the identity that is claimed beyond what
they have in front of them.
Exactly.
Which is why the petitioner in the interview with Citi said he found the conclusion that there was no conflict of interest to be strange. Right? This is what he said. Right?
You see, let me say though that it seems to me that CHRAJ reduced its efforts to what Okujeto Ablakwa himself claimed. Because if you go somewhere in the report, and if you, with your permission,
but they are dealing with the petitioners. They can, I don't know if they can. Can CHRAJ go beyond what the petitioner seeks? Is it possible to do this? Because I know that I've heard before that sometimes when
you deal with what is before you,
exactly.
But in order to do a 360 job, it will require, in many cases, to go beyond what is claimed superficially.
Okay.
Because under the law, CHRAJ has the mandate to summon documents which are relevant for determining a matter before it. The question is it the case that the gentleman who is being accused has some other identity allegedly presented before another institution?
So they could have chosen not to restrict themselves to say passport.
The passport matter, exactly.
So they could have decided to do driver's license, birth certificate, and all of those if they wanted. Some could also say that I think the lawyer for Kusi Boateng was on Eyewitness News yesterday. He said that the Ghana passport is the main form of identity. I think.
Yeah, but you see, that is not even the point. That matter was determined within the context of elections, and what to present for purposes of identifying who is a Ghanaian and all of that.
Can we not stretch that to identity of a Ghanaian? Because I thought there was a case that said that a birth certificate is not a proof of identity.
The Supreme Court said that within the context of determining who is qualified to register.
It shouldn't be broadened to mean that only the passport identifies it.
Yeah, but in this particular case, the question is whether an individual is acting in two different capacities with two different identities, but pretending allegedly to be different people and not connected in any way to one another. If you go into the report, page 10, there's a paragraph there, 6, says, on the request for fourth respondent's Victor Kusi Boateng passport, I have compelling cause to believe that he possesses another passport in his Victor Kusi Boateng identity, similar to how he successfully obtained a passport in his Kwabena Edu Jemfi identity. So far, I have secured his Kwabena Edu Jemfi passports, including a diplomatic one. You understand? So the Honorable Hujeto Ablakwa makes the claim that, look, I have evidence. That evidence is that the name Edu.
He has a passport named Kwabena Edu Jemfi.
Exactly. However, I believe, so in this case, he's not saying that he has proof. He believes that the same person has some other passport in the name of this Kusi Boateng name.
Yeah.
You understand?
Which the CHRAJ could not find. So CHRAJ
exactly.
said, for us, the passport we found, and then, by the way, the foreign minister had gone to parliament under a question from the MP to confirm same that when it comes to passports, the man's passports are only in the name Kwabena Edu Jemfi. So you could also say that that is not probably any new discovery.
Exactly. So
but
that's
they
why
confine themselves to the document, the claim the petitioner made, what they found.
You see, that is where my problem is. I'm not saying that they've done a bad job. I know Dr. Joseph Whittle is a fantastic, brilliant legal luminary in a distinguished in his field. But I'm saying that it would seem to me, and I stand to be corrected.
You are saying these are your preliminary thoughts,
exactly.
Because
if that
got into the full details of the report, just the summary.
Exactly. If that is the case, then there are problems there. They ought to have gone beyond that.
All right.
Now, having said that, and I think that the criminal element of it would have to be delved into by the Attorney General to determine whether these people are the same and whether there are issues to do with that. But, Bernard, I think the bigger issue has got to do with the damning findings made by CHRAJ concerning the individuals who sanctioned procurement processes that are, on the facts of the findings made by the CHRAJ report, in conflict with the law.
Let me just say something quickly. The payments were made in 2021.
Okay.
The procurement of the services of the contractor or the company was prior to even 2021.
Okay.
The resignation from the board was in 2022.
Okay, then.
So August 2022. So the letter that wrote was in June 2022. He resigned August 22. Eastwood and Duncan also followed within the same period. So the incidents reported of took place before the resignation, just for the record.
Exactly. That's good. And that's why I raised the issue earlier. So you see, I note CHRAJ's attempt to say that the individuals may or may not know the nuances of corporate governance obligations imposed on trustees or board directors. So may or may not. So they may know or they may not know. So that's enough room for them to wriggle out of. But Bernard, that without more does not allow you as a person sitting on a board to have the way to argue that you have nothing to do with it. Because if you are appointed to serve on a board, you knew or ought to know that these are the obligations that come with your mandate. And that you are the people who are going to ensure that officers who are steering the affairs of that institution act in a way that is consistent with the law.
Sky, I think that is why in the June letter that Doug Hayward Mills wrote, he raised specific questions about the role of the board, if you permit me.
Okay.
June 22, Charismatic Bishops Conference, completion of National Cathedral. I write this letter as a further letter to my first letter dated 2nd October 2018. So the issues he started raising were from 2018. My second letter dated 4 December 2018, and my third letter dated April 2021. So this is a timeline, which I wrote to chairman and to all trustees of the National Cathedral. I do not believe that all the things that I wrote earlier, I do believe, forgive me, that all the things that I wrote earlier are valid and perhaps even more pertinent at this time. So this was a fourth letter.
Beautiful.
So you have October 2018, December 2018, April 2021, and now June 2022. I wish to state that I am a full believer in the National Cathedral, and my involvement in the National Cathedral is only because I believe in the President's vision. I feel pressed to write a further letter to suggest again some ideas that I believe will help move us forward. It is important to organize ourselves strategically from this point onwards so we can complete what we have started. At this time, I would like to make some additional suggestions to the Board of Trustees so that all trustees concerned with the Cathedral will take time to consider again my meager contribution and suggestions on this all-important project. 1. Or A. Definition of relationship. I suggest that the relationship between the state and the church in terms of National Cathedral be defined properly in such a way that we all understand our place and roles. As it stands, it has been mentioned that National Cathedral is somehow registered as a state organization under the National Monuments and Museums Board. It is also a fact that National Cathedral is registered as a private company limited by guarantee. These two types of organizations are very different, and even if there is a complex relationship between the two, we can define and clarify the relationship properly if we attend to it seriously. I suggest we have 3 bodies to accomplish our goals: a Board of Trustees, an Executive Council, and a Government Council. B. Role and responsibilities of the Board, Executive Council, and Board of Trustees. So it goes on to give suggestions. I do recall that I spoke about this. So now, the reason I'm reading this is that in subsequent communication, the reason he resigned was that he said things were happening that he did not know, or he, as a board member, was not aware of. So they will hear that somebody's building something, somebody's doing something, and they don't know what's happening, but they are on a board. So I'm using that to come to the point you are making about the role of a board, which is possibly why the 3 resigned. If you can read that.
Also, Bernard, there was a response from the National Cathedral, the Board of Directors, to Bishop Dag Mills, which I also have here. So, I mean, if you are done with Bishop Dag's reasons for resigning.
So this one was not a resignation yet. This one was the suggestion about how they were composed.
Right.
The resignation is now 14th August. Dear sir, so let me read the resignation letter. Resignation from National Cathedral Board of Trustees. 1. I'm a firm believer, and this to the chairman, I'm a firm believer in the President's vision to build the National Cathedral for Ghana. I wholeheartedly support the President's ambition to build the National Cathedral to the glory of our Lord, and have desired to freely contribute to the project in every possible way. 2. I put my thoughts, ideas, and suggestions and questions and comments in writing for discussion at our meetings, so they could be addressed in an organized fashion. Further, it is out of respect to the Board of Trustees that I have spent several long hours to write and address the chairman and other honorable members of the board in a thoughtful and coordinated fashion. 3. Thank you for the audience to address my last letter written to the board dated June 22, which highlights I read. Respectfully, there are matters arising from our conversation at the meeting of the board of 8 August 2022. 4. Our meeting on 8 August 2022 did not address satisfactorily the issues I put forward in my letter to the Board of Trustees dated June 2022. I do feel that the treatment of the issues I have raised in my several letters have been unfortunate. My letters have been ignored in the past, not attended to for years, and at best addressed flippantly. You may recall I have spoken passionately and written extensively about the costs and design, the location, the fundraising, the mobilization of the churches, and the role of the trustees. Take note of the role of the trustees. These, if heeded to, would have made our project more achievable. Generally speaking, my inputs, my opinions, and my letters have been trivialized and set aside. As per the President's verbal appointment of myself at the beginning of the project, I was named as one of the Board of Trustees and have approached our work on the board as diligently as I can. In recent revelations at a board meeting, I learned to my surprise that I am not duly so registered as a director of the company of the National Cathedral of Ghana, a company limited by guarantee. Instead, some other people whom I have never met are the real trustees of this esteemed board. I do not believe this is an oversight, but a deliberate exclusion from the board. 6 years is a long time to correct this failure to register me, if indeed it was an administrative lapse. 6. I have therefore accepted for some time now that I am not a trustee of the National Cathedral, but I still have sought to help with the National Cathedral because I believe in the President's vision and I do not have to be a legally registered trustee to do so. I refer to myself in this letter as a trustee because even though I'm not privy to most of the weighty decisions of the board, I am referred to as such. Take note of my emphasis. The role of the state and the church in this project continues to be unclear. This lack of clarity is robbing our vision of the validity it needs. Over and over, I have asked that we address this appropriately and urgently because there are many dire implications to the trustees and the individuals involved in the project. 8. It is noteworthy that the duties of directors as per Companies Act, Act 992 2019 171 states, quote, directors means those persons by whomsoever name called who are appointed to direct and administer the business of the affairs of the company. Obviously, we as trustees are not the ones directing and administering the affairs of the National Cathedral. Most of the weighty decisions concerning this huge project are not taken by the trustees. 9. I have been a reachable and available trustee and attended every single meeting of trustees since this pandemic began, in person and by Zoom, and the record should show that. If I say that I, as a trustee, do not know many of the financial and technical issues concerning the cathedral, it means the discussions about the National Cathedral were held by some people outside the trustees' meetings, or perhaps in the forum that I was not present or invited to. 10. The National Cathedral of Ghana is a company registered by guarantee, placing fiduciary duties on its directors and trustees. I am concerned because I have so far not been involved in any financial issues or decisions, nor have I been involved in deciding on the technical issues of this huge project. And yet, it seems some of these massive decisions are being erroneously ascribed to us as trustees. The few technical and financial issues I have raised in my letters have been ignored, set aside, and disdained. 11. On the one hand, the National Cathedral is said to be a government of Ghana project, with the government taking financial decisions. Yet on another hand, at meetings, it is implied that the trustees have taken or participated in taking these decisions. Examples of such decisions are as follows. A. The decision to get a quantity surveyor to cost this project was not taken by the trustees. I know of David Ajay as the architect, but I do not know of any independent quantity surveyor who costed the design of the architect. Listen to this. So I know of David Ajay as an architect, but I do not know of any independent quantity surveyor who costed the design of the architect. The cost of the project is determined by the quantity surveyor, whose work would then be challenged or accepted by the client and lead to some modifications of the designs. I do not know of any consultant quantity surveyor ever presenting the costs of the design given by Mr. Ajay for analysis. To my knowledge, no quantity surveyor has priced this project and presented it to the trustees for approval or vetting. Very critical point, Sky. The relationship between a surveyor, a QS, and an architect. Because you know that if an architect comes to the design, he needs a QS, then we match the two. B. I'm aware and therefore not involved in how the price of the project has kept changing at different times and has been presented to and accepted by the trustees. I am unaware of and not involved with the decision that a biblical garden and museum should be added to the project, resulting in massive price changes to the project. D. I am unaware of how the cost of the gardens and the Bible Museum were arrived at. E. As a trustee, I equally read in the news of many issues concerning the National Cathedral and I am as surprised as the public about these facts, most of these facts. F. The fact that trustees do not know what is going on is affirmed by the fact that at a point we were asked not to answer questions about National Cathedral to the press, and only one person was supposed to speak to the press. If we as trustees who are managing the business of the cathedral, how come we cannot reasonably answer any question concerning the cathedral? Indeed, it is because we truthfully do not know much about what is happening that we are told not to answer the questions to the press. G. In the recent press conference we held, we did not actually answer many of the pertinent questions posed to us as trustees because we could not. Some of the news reports put the estimated cost at $100 million in 2019. In 2021, this same project was estimated to cost $200 million. Another board member told the media that the estimated cost for the construction was $200 million in 2022. Then in June this year, it was said on GTV that the estimated cost was $350 million. Then the lawyer for the Italian firm Risani di Ecce mentioned that it cost US, I think the figure didn't come, a different amount. Then, again, in an interview with Legal 500, a website that publishes analysis of the capabilities of law firms around the world, Simon Bagnariol, the lawyer, said his team has been able to finalize a $400 million contract for a cathedral project in Ghana. Obviously, he did not finalize the contract with trustees nor give us a bill for that. How come we are now the ones said to be seeking a loan to pay that amount of money, which we don't know how or when it was arrived at? Who are the unknown persons or bodies who transact this business on behalf of the National Cathedral? Should such agreements and businesses of the cathedral then be ascribed to the trustees? I am unaware and not involved in how the price of the project moved from an initial cost of $100 million to an eventually become $400 million. How then could the trustee be the one to seek a loan for a bill to which he does not know how it was generated? It's serious, Sky. He lists about 10 other things he's unaware of.
Yeah.
And then concludes that if I do not know all these things and how they are being done, I cannot claim to be a trustee who is managing the business of the National Cathedral. At this time, I realize that I am unable to function on this board and wish to withdraw and resign from the Board of Trustees. I have waited for clear and unambiguous clarification and responses on different issues, including the roles, the responsibilities, and the liabilities of us, the trustees, the government, and all other unknown and invisible stakeholders. All I've received is a condescending and disdainful response to my letters. My support for the construction of the cathedral is unflinching. I have desired and supported this project ardently from the beginning. No one, including members on the board, can ascribe to me the posture of one who is an outsider or one who has not and does not support this vision. It's unfortunate that my letters over the last 6 years of this project seem to be more of an aggravating annoyance than someone helping to build the cathedral. Unfortunately, I cannot continue to function as a on a committee if my input is perceived as opposition to the case, to the cause. I'm truly sorry to have come across as a stranger, an outsider, and a troublemaker. That has never been my intention, and thus I have seen even more the need for my resignation at this time. Then he goes on to Sky. The point I'm making goes to the point you raise about what CHRAJ said about the board, and I think this letter, among other letters, points to the grave
infractions
in terms of corporate governance,
corporate governance,
which CHRAJ identifies, and he lists. If I didn't even finish, he lists plenty of things that he. And by the way, you can say that this series of letters should have warned all of us about what was going on, even before Okudzeto's petition to CHRAJ.
Except that they were not made public. These letters were originally confined to the institution he was writing.
No, actually, we reviewed some on air.
Yeah, but it was subsequent to his resignation that some of these things became public. Now, let's get...
No, they were public.
No, I don't think
no, they were not officially... Okay, you're right. Yes.
He was seeking to cure the mischief.
Yes.
If there was one.
Yeah,
but now we know that there was mischief.
Yes, but the point I'm making is that when you put all his letters together, it goes to strengthen the finding of CHRAJ.
Exactly.
Of procurement breaches and poor corporate governance.
Yeah, you see, but Bernard, let's speak to something. He said something specifically in the letter that there were people registered as trustees.
Yes.
You understand?
Of the company.
Exactly. So, under the law, if the question is asked, we want to punish people who took decisions for and on behalf of this particular institution, committing public resources, leading to losses.
So he's not part.
Yeah, that's right. On the facts, if the evidence suggests that he was not registered, then we cannot reasonably be seen to be asking him questions.
Which is why, you are right, which is why he said, if his exclusion was administrative, 6 years is a long time to correct it.
Exactly.
So the fact that the correction was not made, he believes that he has never been a trustee.
Exactly. Unless there is something constructively to prove that although he was not registered, by reason of conduct,
Yeah.
one can
Yeah.
infer
Yeah.
taking decisions for and on behalf of the institution,
And for me,
leading to
I'm not even going.
losses.
What I want us to look at is the conclusion of CHRAJ is very serious. And again, I'm saying that as media, we have a responsibility to let people understand the seriousness of the issues.
Very serious matters.
Whilst double identity is an issue, I think 260 million cedis spent on a project over a number of years it was spent, with the grave procurement breaches requiring the CHRAJ to even instruct the authority to abrogate the procurement on the basis of the Public Procurement Act. I think it's very serious.
Yeah.
So we should not let the bluster and the, I don't want to use the word propaganda, because there are things that are easy to follow. But Sky, 260 million is a lot of money.
Yeah, it is.
And to have the kind of hole that we have there. I mean,
Foundation.
Sky, we spent 260 million cedis. And I don't even think the foundation has probably been built. Alright? We have projects that have been started in the country that have not been finished. Hospital projects have not been finished. School projects have not been finished. For me, it is a monumental embarrassment that we sat down for this to get to this point. Okay. And we owe it to the public to look at the specific findings of CHRAJ and make them known to the world, and not just sort of look for the equalization, who has won, who has lost, because it seems as if right now we are saying Okujeto won, Kusi Boateng won, because on procurement Okujeto is right, foreigners of interest Kusi Boateng is right, so that's where to end. Any serious mind reading the letters of Bishop Dag from the first letter, now the letters are public, clearly this was not being managed the right way.
Bernard, let me say from the outset that look, I believe strongly, and I don't care what views people hold, that we need a national cathedral. I hold that view. That as a matter of things to be done, Ghana needs a national cathedral. That is my view.
But
the fact that we were programmed as to believe that we were not going to commit public resources to the doing of the same. The fact that Kwabena Bonfe took this matter to the Supreme Court, and that's, for me, one of the major failings that we saw with this particular project. Kwabena Bonfe, formerly of the CPP, noticed that there were efforts to demolish buildings that were housing judges and some other officers of the state,
embassies included,
in order to make way for this project. And he makes a legal argument that this is an effort to promote one religion to the exclusion of the other. And on the basis of that, among other things, proceeds to say that what was about happening was unconstitutional, and that the Supreme Court should intervene and invalidate the effort the government was making. The court came to the conclusion that it was not minded by, it was not moved by that argument. That, look, government supports the Muslim people to go and do their Hajj thing, amongst other things, and all of that. So, as a matter of constitutional law, they did not take the view that what the government was doing was unconstitutional. I have my own difficulties.
So when you say you support the National Cathedral, you support the National Cathedral paid for by, not by the state.
I support the building of a national cathedral if we can, as a country. If we can build it, yes. If we cannot build it, is it possible to raise funds from other sources to build it? Because
no, but I thought the key question was whether the state should be the one using state funds to build it. I think that was the key question.
Oh, yeah, that was the key question in the sense of the constitutional argument he raised. He raises that and says we are committing public resources. And to the extent we are doing
and
that...
Saying, do you agree with his argument that you shouldn't commit public resources to it?
I don't think. If we have the means to do it, why not?
So you are...
Yeah.
Okay. So are you saying that the court could have saved us all of this trouble if they had interpreted favorably for the Bonfe?
Yeah, but then...
have reached here with all these challenges.
But that would have led them to the conclusion that they were indeed furthering the interest of one religion to the
so because of the premise it came from.
Exactly. So that's the but I'm saying that I believe that there should have been a more, with the greatest respect to the Supreme Court, there should have been a more nuanced approach to dealing with the matter he brought.
My concern is how a project of this scope, one of the respondents, according to CHRAJ, said that, when it comes to some decisions, we don't take minutes. We just agree among ourselves.
Yeah. Is it?
Now, I'm a bit shocked because, see, the little small management meeting you go to, you have to, any resolution or decision has to be properly documented.
Yes, that's how it is.
So for a respondent to tell CHRAJ that, we just agree among ourselves and we don't take minutes, I think it's scandalous.
It is.
Especially, this is a national project of a huge cost. Apparently, from the last check, almost $100 million. So how do you take a decision? So how do you check if the decision is being adhered to?
Yeah. So
because if you say we agree, how do you agree among yourselves without? And I'm quoting
CHRAJ.
The CHRAJ.
Yeah.
So CHRAJ describes it as very dangerous and is recommending for training at IOD.
Yeah.
But my other challenge I need to ask you is, how is CHRAJ saying that they don't have capacity to investigate criminality, and yet they are inferring to prosecution?
Yeah. So
why are they making that inference in their?
So if you look at the constitutional provisions establishing the commission, under specific circumstances, they can come to conclusions that will require additional work to be done by.
But how do you conclude before you do the work?
No, it's a basis. It's a question of looking at the facts, relating it to the law, and coming to a passable conclusion as to what has happened.
Okay.
But then not making a categorical claim that this finding of fact has been made, and therefore the people.
I'll let you tidy that up when I come back, and then take a few more reactions to the conclusions. So the first conclusion, no conflict of interest. Second conclusion, grave procurement breaches. And then the history of this case with the letters that were written. If the epistles had been heeded to, we may not have been left. Yes. Where does this leave the National Cathedral? Because even with this CHRAJ work, which our analysis shows at best is mixed, right? Even with the mixed outcome, the paragraph spent on the procurement breaches and the admonishment of the procurement authority to stop the initial procurement to the company that's supposed to build the cathedral, plus corporate governance infractions that they identified. Can we say that this makes the position of the cathedral untenable, or are these things you can remedy? Because of course I've added some of the historical issues as well. Just because, as I said, there are two issues: conflict of interest for Kusi Boateng, which they did not find, and then procurement breaches, which they said they had glaring, and then of course corporate governance management breaches, which were not necessarily petitioned, but the CHRAJ found copiously that there were a lot of corporate governance weaknesses in the way the press is being managed. So the question is, for listeners to get a clear sense, where does this leave the cathedral? Is that the end of it? Should they dissolve the whole thing? Where do you, based on this?
What do you do with the 221 million Ghana cedi hole? What do you do?
That's the question, right?
You can't just leave it. Something has to be done with the area. But what is clear is, and again, I think anybody who has listened to this panel on this particular topic would realize the consistency, will notice the consistency on this. This particular project has suffered from a lack of national consensus. Two, was basically built from a lack of process. It was being made up as they went along. And I, for the life of me, do not know which proper country you initiate a $400 million project and you make it up as you go along. Also struggled and suffered because those who started it under the guise of, this is the president's dream. We can do whatever we want because it's the president's dream. And by virtue of the fact that it was the president's dream, the systems and institutions that are weak in this country allowed this to go. Because if you go and touch it, you are touching the president's dream. Everybody was afraid. which is why the procurement breaches, the lack of frameworks and structure. If you recall, it took almost a year and a half for us to be told that it had now been subsumed under the Ministry of Tourism, under some guys. We didn't know exactly what it was. How do you dream up a $400 million project and you don't even know under which sector it was going to go? This was all, if you wanted to do it, this is a 20-year dream for every country. It is not a 3-year dream, it's not a 4-year dream, particularly one as poor as this country. Yeah. This is a 20-year dream that a country carries along, because you will require different governments to buy into it. So this should never have been sold as a personal vision that later on metamorphosed into something else, because first we were told there was not going to be any state funds allocated, then something happened, but we know that millions of state funds have been put in there. It's really disappointing. So if you ask me where we go from here, I'm saying we have a 221 million CD pit in the heart of Accra that needs to be resurrected one way or the other. Somebody also has to pay for it. So and I'm with CHRAJ on this.
The foundation hasn't even been built yet.
They haven't done anything. You see,
add all the demolitions that have been done.
I am very disappointed in the persons who started out as trustees, those who stayed on as trustees, those who resigned, whichever one, everybody who was involved at every stage of this needs to sit back, read what CHRAJ has said, and ask themselves, did I really do the best that I could as a Christian? Because that is what they are first. They should ask themselves that question. Whether they really, because I've seen some of the comments around the National Cathedral, even in the face of absolute public disdain for this particular cathedral. People who are on this board telling the public, "Mumpo will build it," as if it is their money. Meanwhile, you are traveling around on public funds. So, this CHRAJ report is something, I hope all, how many pages?
160, is it 165?
165. They should sit down and read it by themselves and ask themselves, did we do well for the people of this country? That is all I'll leave them with.
We'll leave it there.